Okay, we're going to go ahead and start this public meeting. My name is Gary Brimley. I'm an adjudication engineer with the Utah Division of Water Rights. And this public meeting is for the Little Cottonwood Creek Subdivision of the General Stream Adjudication in the Utah Lake and Jordan River drainage. We are streaming live tonight on YouTube, so we would ask for a few rules of engagement. If you have questions, go ahead and raise your hand and we'll take them during the meeting. Also, after the meeting is over, we have staff that will hang around for a few minutes to help answer some more detailed answers on your more detailed questions. Other than that, you're welcome to ask in some generalities that are hopefully applicable to the audience as a, as a whole. Other things regarding just some other information here. The meeting is about an hour long. We want to keep our talking within the room to a minimum so that the recording doesn't pick up the extra noise outside. There are some restrooms outside if you need to get up and go there. And attendance is not required. This meeting is an informational meeting. You've received a summons in the mail telling you that you are joined as a party or as a potential claimant to this adjudication, and we'll go into quite a bit of detail about what that means tonight. I'd like to introduce a few of our staff that are in attendance and thank them for being here. First of all, John Bream, who is the adjudication team leader, is kind of the boots on the ground person who will collect and process and analyze the claims, and his team. Also we have Jared Manning in the audience. He is the distribution engineer, the assistant state engineer for distribution. And Mike Silva is also in the distribution section. And I have the Attorney General's office is being represented for me by Sarah Schechter, and is sitting over on the side there too. And she's the state attorney that is over adjudication for all of our activity that we're doing here. Go ahead and do I'll go ahead and do the agenda overview. So we'll talk about what the adjudication does and what it is, and then we'll tell you about the proposed determination process. And of course, I will help explain some of the terminology used, and then we'll look at the significant issues and anticipated timeline in this process. And then I'd open it up for more broad questions, and I'll offer to stay as late as we need to get all of your questions answered as thoroughly as possible. And I will be monitoring questions online for our online viewers who are watching live. You may submit your questions to this email address, waterrights_adjudication@utah.gov, and I'll monitor that after the end of the meeting or maybe toward the end of the meeting, and we'll see if questions have come through on that email address. So let's start with what a water right is. A water right is a right to take out of its natural source the waters of the state, and beneficially use it. So the defining elements typically include a nature of use, what the water is being used for, such as irrigation or domestic purposes, and a priority date, which is when the water right was initiated, and a defined quantity of water, the amount that is used in terms of acre feet, which is defined as 1 acre of land inundated by a foot of water, a depth of a foot of water, or a flow rate of a cubic foot per second. And it would include a point of diversion, so that is where the water is taken from. If it's a well, then it defines where that well is located on the map. If it's a stream, then it would tell us where the head gate or the diverting works for that water taken out of that stream is located. And the place of beneficial use, which is done by public land survey information. And a water right might be evidenced by a wellhead. So you might see a well located on your property, such as in the first picture, or irrigation ditches or head gates, such as in the second, or a stream collection box or a spring collection box. But a water right is not a share in an irrigation company. So a share evidences a portion or a share ownership in a company where the company is the water right owner. So a shareholder would not be the owner of that water right, but the company is. And likewise, a water right isn't a connection to your public water supplier, although the public water supplier would be the water right owner and you would be a customer to that public water supplier. But a person may have their own standalone water rights that are separate from their shares or separate from their municipality. And do you have a question over here? I do. Okay.
If you have a public water supply or water right that is connected to a private system, is that water going to be in the adjudication as well?
So he asks if you have a public water supply right, or if you have a water right that is provided to you, I suppose, via a municipal or public water supplier, then he's asking...
Not a water supplier, a water right that is owned by a municipal entity.
Okay, so if you have a water right that is owned by a municipal entity, all water rights are involved in the adjudication, and all water rights are being adjudicated in the geographic area of this subdivision boundaries of the Little Cottonwood Creek subdivision. So yes, all water rights are under the adjudication order. All water rights are subject to the Utah-Licon General. All water rights in the subdivision are subject to the adjudication. Yes, sir.
Okay, when you say if you have a share, a ditch company owns the water right, and we have shares on that ditch company, correct? So we're here because we have those shares. Who is responsible for proving up on that, on the water right and on the share?
Okay.
Is it the water company, the president of the water company?
Okay.
Or do we still have to fill out the paperwork?
Very good. So the gentleman is asking who is responsible to, and he used a term proving up, and I think that we want to make sure we're not confusing terms, and I will get into the filing of water users' claims in this action. So we'll get to that question a little bit later, but I would say that the water right owner is the responsible party to make sure that a claim is filed in the adjudication. So we'll address that slightly in more depth later, but I think that that is a broad answer to your question, that the water right owner is the responsible party that needs to be filing a claim. So here's why kind of we're doing an adjudication. In the historical context, the pioneers arrived in the valley, Salt Lake Valley, and they started taking the water out of the streams, and they established water rights by doing this. So they established their use of water out of the streams. They built their shopping mall on top of it, and in 1848, Brigham Young declared that there won't be private ownership of the streams that come out of the canyons. These belong to the people. So water rights, or all the waters of the state, let me say it very clearly, all the waters of the state are a public resource and belong to the people, and the water rights are administered and owned by the people. So rights to use the water are owned by the people, but the waters belong to the state. The pioneer settlement became part of the state of Deseret and then the territory of Utah, but the point here is that the government over all the affairs of the land, including water, was church-centric. So the diversions of water were generally on a community basis to meet the immediate needs of settlers, and the doctrine of priority evolved from the church leaders' recognition of groups who put the water first to beneficial use, and then later beneficiaries. So there were primary and then there were secondary rights, and this is an example pattern of how priority came into being. So the first in time was first in right to use the water. Conflicts were settled through ecclesiastical channels. So bishops' courts for local wards provided a judicial process. Stake high councils served kind of as an appellate court in style. And disputes or conflicts were settled that way through church governance. So the territory of Utah, the first territorial legislative assembly passed an act authorizing the county court control of all timber, water privileges, or any water course or creek. But Salt Lake County was really the only one to assume these duties, and other counties kind of stayed out of it, and streams were still diverted without much restriction. In 1877, the Desert Land Act was passed to promote homesteading of arid and semi-arid public land. The act also severed the title of the water from the public land and delegated authority to the states to appropriate waters. So the states had the authority to govern it, so it was no longer a federal governed or a federal control. In 1880, due to the failure to enforce the 1852 Act, the territorial legislature passed an act that replaced county courts' authority with county selectmen as ex officio water commissioners. This was once again only enforced in a few counties, and sometimes certificates were regarded as worthless. And then confusion arose over existing water rights, and this was in spite of efforts of the territorial legislature. So the church continued to administer and decree water rights in some areas. So we come to statehood in 1896. So the Utah Constitution was written to include a provision that reads, all existing rights to the use of any of the waters in the state for any useful or beneficial purpose are hereby recognized and confirmed. So this is very vague and broad and kind of general, and it says that, okay, in 1896, all the water rights that exist, they still exist. But at this point and through this point of time, we didn't have all of those water rights written down on the record. They just still existed. So in 1897, the Office of the State Engineer was created and tasked with conducting hydrographic surveys to bring all of those water rights onto the records. So appropriations were made by posting a notice at the source, the nearest post office, and the county recorder, but that was largely ignored, and the state engineer was charged with bringing all of those rights onto the record. In 1902, a federal act was established, or the Bureau of Reclamation was established to reclaim arid lands, which meant they were trying to do water development projects. But before the federal government would allow for reclamation projects to begin, the states had to adopt comprehensive water statutes. And this led to a comprehensive water statute being adopted in Utah. So in 1903, Utah adopted its first comprehensive water law, which provided for appropriating waters and recording all existing water rights and the adjudicating of water rights by the court. Question?
Yeah, I'd like to know who maintained and paid for the transmission of this water? Was it the state or was it up to the water right users?
Okay, so lady asks who maintained or paid for the conveyance of the water? The transmission of the water.
The state obviously owned the water. Who was obligated to transmit and pay for it?
Very good, okay, very good. So it costs money. So water users are responsible to pay for their works and maintain their works. Okay.
So all the storage and whatever they needed to hold the water and the pipes needed to
The purveyors of that water would have the obligation to maintain their ditches, their canals, and pipelines, if any, and their headgates and diverting works.
Okay.
So water right owners and the government would not step in to pay for that. Now, the federal government did projects, which I alluded to, as the Bureau of Reclamation came in to do projects. But the moral of the story is that our comprehensive water law came about because of the anticipated projects by the Bureau. So we adopted a comprehensive water law in 1903. And in 1919, the legislature provided the machinery to adjudicate water rights on a given stream by directing the state engineer to develop a proposed determination of water rights for the court to consider. That introduces the proposed determination process, which we still abide by today, which 99 years later, we do proposed determinations, and that is what adjudication is about, which I will go into more detail. Now, in 1935, the legislature required all groundwaters, all uses of groundwater, to be appropriated through the state engineer's office, similar to surface water in 1903, which it mentions that on our 1903 line, that the legislature provided for appropriating surface rights. So there's some cutoff dates, if you will, some, maybe not cutoff dates, but some timelines wherein if your water right was established prior to that, it would be considered a pre-statutory right because it predates statute. So surface rights established prior to 1903 would be pre-statutory rights. 1903.
Not 35.
1903. And groundwater rights established prior to 1935 would also be considered pre-statutory groundwater rights. Yes, sir.
Is water emanating from underground mines considered groundwater or surface?
So the gentleman asks if water emanating from mines underground is considered underground or surface waters, and I would have to suggest that the answer to that is semi-vague, but probably groundwater.
What's the semi-vague part?
What's the semi-vague part?
That it surfaced.
That it surfaced. It was developed from underground flows and underground sources, so it would probably be considered underground waters.
But you're not certain.
I think that Jared's putting his hand up.
I would just add, sometimes mine companies will de-water mine, the water will go into the natural channel of the stream, and then at that point it becomes commingled with the surface supply, and then it becomes surface water. But if you're gonna divert it and use it from the mine tunnel, then we'll usually consider that to be groundwater.
So the portion
So,
makes it to a flowing stream becomes surface?
Generally, yeah.
yeah, in order for the
Non-general part.
So in order for the live stream and the YouTube to capture what's being said here, the waters developed from a mine tunnel and used at that source or from that source would likely be considered groundwaters, but if they had not been diverted and used there, if they had been discharged to a stream, commingled with the stream, then that water becomes surface waters. So moving along here.
Is that by statute or practice?
Whether that's by statute or practice, I don't know. So the historical case for adjudication calls for bringing rights onto the record in most cases. So as I said, the Constitution from 1896 recognized all water rights, but it was that short, it was that brief. It was in Article 17, and it was only a few words long, and it said all the rights are recognized, or they're still rights. And we didn't have them on record, so in order to bring them on record, we do adjudications. So prior to the enactment of Utah water law, rights typically fell into a combination of 5 categories. They were those decreed by ecclesiastical leaders, those filed for record at the county, those decreed by a court, which typically involved limited parties, so only a handful or a short number of people were involved, so neighbors weren't involved. Contracts or agreements among limited parties, and claims never manifest in any record, but they can still be evidenced today by pre-statutory use with proper evidence provided. So this leads to these five types of categories. The lack of a definitive water law created a lot of issues, such as no public record existing and over-appropriation of streams. So more people wanted water than there was flowing given to us by Mother Nature. So of course, streams were dewatered and over-appropriation was common. And rights weren't very well defined until they came into controversy and had to be settled by those ecclesiastical processes or judicial processes. In his biennial report for 1901 and 02, the state engineer observed as follows: "The definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record." So recall that in this short timeline, when the state became a state and the water rights were unknown, the state engineer was recognizing that we need to know what they are. We need to get them onto the record. So a general stream adjudication is that action that brings the water rights onto the record and fully settles what they all are and defines them all. It's an action in state district court that binds water users and the state engineer, governed by Code, Utah Code, Title 73, Chapter 4. The first general stream adjudications took place in the 20s under the Sevier, the Weber, and the Virgin River basins. And today, if you'll notice, in the purple there is the Utah Lake and Jordan River general adjudication outlined in the heart of Utah in the purple color there, and it says 1944. This date is given as the date when the general adjudication of the Utah Lake and Jordan River commenced. So the action became a general adjudication in 1944 and is ongoing today. I understand it to be the oldest unsettled action in the Third Judicial District of the courts of Utah. So this is the oldest unsettled action in the Third District. So why we conduct them? To bring rights onto the record. Recall the pre-statutory claims, the Dos Equis man who doesn't always file a claim, but now he's going to. It's 100 years later. And he might have a diligence claim that predates 1903 or an underground water claim that predates 1935. Also to bring Federal Reserve rights onto the record, which most areas of the state presently aren't known. So the government, or the federal government, has claims to waters for various purposes mostly on federal reservations, which would be Indian reservations, Forest Service reservations, and the like. And Federal Reserve rights are undefined. They're out there. They exist, but we don't know what they all are. And so in order to get rid of that uncertainty and help all of us know what we're subject to and what they're subject to, so that we can settle those claims between us and the federal government, we adjudicate them. And this is unique because we can join the federal government as a party in state district court. That's unique because you usually can't sue the federal government, and even if they let you sue them, you usually can't sue them in state court, but we get both in this case. And to prevent a multiplicity of suits and bring clarity to the water rights picture, so that, we don't have just limited parties participating, but we have everybody participating. That way we can adjudge and weigh everybody's interests in the hydrologic system, or the watershed, if you want to call it that.
Does everybody participating include the federal government?
Yes, we tend to join the federal government on a subdivision case-by-case basis.
So right now you don't know what the federal government claims are.
So right now we already have received the federal government's claims in broad strokes. They've deposited with us their claims, and in this process we adjudicate that and we come to a settlement. We propose the determination to the court, and that gets settled in this process.
So if there's an adjudication taking place, you've got somebody claiming water rights in this particular spot, the federal government has claimed that same area, who wins?
So he asks who wins between a private party and the federal government, and that's always to be determined. So that's always part of the process. That plays out during the process. I can't tell you that one party wins over another. It is always to be determined through the process. And we had another question over here.
Are there any federal claims in Book 23?
Are there federal claims in Book 23? The answer is yes. So there is a broad claim that the Forest Service has filed on forest lands, and then John in the back, the team leader, tells me that there already are 2 other claims on record by the federal government in the Book 23 area. So all parties are brought to the table, okay? So all parties have their participation in this matter. And a third reason is to remove or reduce rights that were of record but have been wholly or partially abandoned or forfeited through non-use. So in the history of the state, it's, you know, we've been a state for more than 160 years. Or no, we've been a state for 120 years. Thank you for the correction. We've been settled for 160 years in this Utah area. And rights that were initiated once and have been left off, have been disposed of or abandoned, or, you know, the settlers walked away from them, don't use that water anymore. Those rights are removed through this process. Only going forward after a proposed determination and a court decree on the general adjudication, only valid existing water rights that are in use are remaining. Yes?
How does the Forest Service prove use of water?
How does the Forest Service prove use of water? That gets into a little bit of detail. I could probably, I suppose I could address it in broad strokes. If they're using the water, that would be one way. If they show that they're using the water from a source. We could talk about it later. Okay. Yes, ma'am.
Could you explain, you used the broad term Book 23, what did that mean?
Okay, Book 23. Book 23 is the subdivision book boundaries, and we call it book because we're preparing a proposed determination book to submit to the court. The book would consist of a list of all the rights in the subdivision, and the subdivision's number is Area 57, Book 23.
Okay. Thank you.
And finally, to obtain a final comprehensive decree on all the water rights within the respective drainage. So these are the reasons why we would conduct a general adjudication. And so here's the process kind of in broad strokes. It began with a petition, which I mentioned was from 1944. We're getting to it to today with a notice and summons in a public meeting. And following today, we will send out notice to file your claims. The notice and the state law, the state code, requires that claims be filed within 90 days of notice being sent. An extension can be granted upon request, and a water user might also file a petition with the court to, with the state engineer or with the court. In either case, an extension can be granted for up to 30 days beyond this 90-day period. Then, after the claims filing period is over, the state engineer publishes the list of unclaimed rights. Now, this is a little unique thing that I'll go into in more detail later, but it just lists all of the rights that were of record that didn't have claims filed on them. People would have an objection period, and we would hold a public meeting after that list is published and resolve those objections and seek a decree on that list, followed by claims investigation. So when we receive water users' claims, which I will go into more detail in a bit, we go out and investigate the nature of the claim. So a person would file a claim, and we will investigate that and prepare our proposed determination to the court. So the state engineer and the state engineer's staff is responsible to prepare this book, Book 23, and submit it to the court, upon which we will give notice to all the water users saying that the proposed determination has been filed, and the water users would have an objection time period open to them, and we would hold a public meeting in that meantime. Yes, sir.
How does the state engineer's office take notice of the public record at the county recorder's office?
He asks, how does the state engineer's office take notice of public record at the county recorder's office? And my answer to that is the burden is on the water user to bring those records to the state engineer's knowledge. In a lot of cases, the state engineer is already aware of decrees on limited stream systems. So we're already aware of a decree on the Little Cottonwood Creek, or several of the decrees that have arisen out of actions on the Little Cottonwood Creek. And if there are any other records that you need the state engineer to become aware of, the onus is on you to provide them to us. It is the water user's responsibility to file their claim in this action, claiming that they use water, that they have a water right, and to provide the substantiation of that claim, of where that claim comes from. Where does your water right arise out of? Yes, ma'am.
Going to number 6, the list of unclaimed rights, will those be listed by parcel, address?
So the list of unclaimed rights, and we'll get to that in a little bit more detail on some upcoming slides, and I'll get to that briefly, so I'll get right to that. So not next slide, but in a little bit. So this is filing your water user's claim. First of all, we do notice that it's time to file your water user's claim and that you have the 90 days. The 90 days has begun, as well as we publish it in a local newspaper. If your right is already, so there are a couple of types of rights. One is those that aren't on record, and one is those that are on record. So we already know about applications that have been in the state engineer's office. Why? Of course, they were filed with our office, therefore they're of record. And we also have record of some diligence claims and water users claims that have been filed throughout state history. So those are rights of record. And so for the rights of record, we send out a pre-filled out, computer-generated water user's claim form with the information that we have on record. And for the rights that aren't of record, so if you claim a right that we don't know about, we send out blank forms to all property owners. So there were about 7,000 or 8,000 property owners that got this notice tonight. It resulted in about 60 or 70 people attending, which is great. And everybody that got that notice will also get this notice to file their claim, and in that envelope will be a water user's claim form with a bunch of blank lines that you can provide your information to us. And if you need help to fill that out, you're welcome to contact us and we will work with you. So in the case of claims that are already prepared, they have the information on them, and the water user should sign on the bottom line and return it to us, which attests and affirms that they are using the water and that they're a claimant. And for all the ones with blank lines, you also fill out your information and return it to us, and we will include your claim in our investigation and evaluation. Claimants have 90 days, as I've mentioned, and they can request one 30-day extension, as I've also mentioned. And that 30-day extension is automatically granted upon sufficient request. So in your request, you do it in writing. You say, I need an extension for the action in the Little Cottonwood Creek Subdivision, and we are charged by statute to grant a 30-day extension upon that request. And then we do our field investigation. So we investigate claims to see that they're in use and to see where they're used from and to see that the information on the claim form is corroborated by the field investigation boots on the ground. So we'll see where the point of diversion is, and we'll see the water in use, whether it's for irrigation or whatever use is being made of it. And then we prepare a hydrographic survey with mapping, and that all becomes the basis of the state engineer's recommendation to the district court. And now here's the answer to this question. So the list of unclaimed rights is a list of the rights that were of record that upon which no claim was filed within that within the filing period, the time of filing. So a public meeting will be held once the list is published it's an informational meeting again, in order to help you understand the list or to identify any rights that might be on the list which you believe yourself to be a claimant of or that you should have filed a claim for. And if you feel like you have a claim that is published on that list, it's a bad thing to have it's subjectively bad. I guess subjectively, because the list is a list of the water rights that didn't get a claim. So if your own water right is on that list and you don't want it to be there, then it's bad for you. So you have a time to file an objection with the court, and that would be a 90-day period. And then we would work through objections to resolve them. Yes, sir?
Is there a list on the state engineer's site right now of water that is being diverted but not being used?
So he asks if there's a list on the state engineer's site right now of waters that aren't in use, water rights that aren't in use. Diverted, but not in use.
Or claimed.
Not claimed. So in the context of the adjudication, there's a list of all the rights that are of record in this subdivision. And that list is actually obtainable and available on our water rights website. If you go through the water rights website, I could show it to you later where the list of rights is. But as to your question, I don't know that there's I doubt that there's a list of rights.
So the list of unclaimed rights that you're referring to will be generated by the adjudication process?
Yes, this list of unclaimed rights would come as a result of our adjudication work. It comes as a result of all the rights that are of record now, presently, that didn't get a claim filed on them. So in this subdivision there, I'll get to a slide that tells us how many rights there are of record in the Little Cottonwood Creek Subdivision, and then there'll be a subset of that number will have claims filed on them, and the remainder would be the unclaimed rights. So we would seek a judicial decree on the list of unclaimed rights, which declares them abandoned. So the water users or the potential claimants or the owners of record did not file a claim on those water rights, and those water rights are considered abandoned. And such a decree that we also seek would potentially have language that may prohibit future diligence claims from being filed in this geographic area. And that means, remember the Dos Equis man whose right is not of record yet? After a list of unclaimed rights decree with a provision that prohibits future diligence claims, he will never again be able to file a diligence claim within that geographic area. So now is his opportunity, and later it's closed off. Are we okay? We're clear? So the PD, the proposed determination. Yes, sir.
If there is an enforcement action for illegal diversion of water, and the parties that are diverting don't make a claim, would they be excluded from the use? Would the adjudication terminate the enforcement action, I guess is the question.
Good question. So he asks if there's an enforcement action in the adjudication area, and if the claims are not filed in the adjudication proceeding, would that terminate those water rights? And the answer to that is in this red box again. In these 4 boxes, if the water right is listed on the list of unclaimed rights, then, and it makes it to that decree stage, then the court is declaring those rights abandoned, and those rights are removed from the record, or in other words, they're abandoned. I mean, the record stays of record, but they are listed as abandoned, so they are invalidated at that point. Yes, sir?
They can't, someone can't come in and try to, if they're abandoned, come in and claim them.
So a water right that is abandoned cannot be claimed after the decree is final.
Yeah, I'm just saying like one of the cities or whoever.
Okay,
Is there, you know,
let me see, so you're wondering if in the future somebody can commence use of those waters?
yeah, say someone abandons their whatever, their water rights.
So there's a process for that, and in order to commence a new use of water, they would have to establish a new right by the proper process for that, which might be a change application on some other existing right, and so forth. There's various processes for that. But as to the water right itself, the right that's of record, once it's declared abandoned, that's final. That water right is gone. Right, that water right would be gone. We're good. So, the proposed determination is the big end goal of kind of our legwork. This is what we want to get accomplished. We want to prepare this Book 23 and submit it to the court. And in order to do that, all the claims that are filed, we investigate, we map them, and we submit that book to the court, a book that would define the characteristics of the right. An ownership name, a priority date, a point of diversion, the things that I said on that earlier slide of what defines a water right. And then there's an objection process that the objection period is open for 90 days if you object to any of the elements of the publication. So if we made a mistake, or if you don't like it, or if it doesn't corroborate with your claim, then we would work to resolve that objection and, you know, come to a negotiated settlement, or we might litigate it. Either way, we have to resolve objections before we seek a decree. Yes, sir.
In the case where there would be two objections, does the state engineer still have the choice to negotiate a settlement?
So in the case where there are two objections, competing objections, can a settlement be negotiated? And the answer to that is all potentially affected parties are given notice to the objection material, the objection proceeding, and would be brought to the table or invited to the table. And
It says the engineer may choose, so.
that's
Can the engineer elect to not negotiate and litigate as opposed to negotiate?
well spotted. I would definitely defer to my attorney if she's willing to speak up on this issue, please.
Let's maybe chat after
Chat after.
this issue.
Thank you. So a broad overview of this subdivision book boundary. As you know, the Little Cottonwood Creek Subdivision boundary, I think a similar map was provided in your summons packet. But here it is. It includes the Little Cottonwood Creek from its upper reaches of the drainage down to parts of the valley bounded by Bengal Boulevard, Highland Drive, and 9400 South. That's just in broad strokes. If you need to seek more clarification of that boundary line, I invite you to look at our map server on waterrights.utah.gov. All the pink dots here represent 154 water rights on record. That's the number that wasn't coming to mind, which I was trying to pull out earlier. So of the 154 rights, many claims will be filed, and some claims may not be filed, and those that aren't would be published on the list of unclaimed rights. Within the subdivision, there were about 7,300 notices sent out, so that includes property owners. So there might be 7,000 parcels of land, tax parcels, county tax parcels in this boundary. There's an even mix of surface and underground sourced water rights. So there's probably, you know, half of them were surface and half of them were underground of record. And we don't know of the water rights that are not of record, if there are any. Issues that we foresee, we obviously there's a lot of issues. We can't list them all here, but here's some. There would be out-of-date title to water rights on state engineer records. This issue might be it might be a thing that you would come across if your water rights came from your predecessors in interest, whether that was in family or whether you bought the property from you know, strangers. The title may not have been brought up to date. So we may have an owner of record from 70, 80, or 90 years ago, and it'll say William Clayton or, you know, John Henry, and it's supposed to say your own name or your family name or your family's LLC or your family's trust and so forth. Another issue would be the location of no proof required water rights. And there's a handful of water rights that were small, defined as small by statute, small water rights that didn't require proof there was a period of time in history in the 1940s and 50s when proof wasn't required on some small water rights, which meant that an application was filed and the applicant was good to go. They didn't have to correspond back and forth with the state engineer after that. They could go drill their well, place the water to use, and never file proof saying that it had been done. And those rights are of record. They're applications that were filed, and they might not have been filed in the right location. So an application for one parcel might be specified over here, but 500 feet away was where the well was drilled. And putting two and two together is the puzzle sometimes. Knowing that somebody's claim 500 feet over here really belongs on that application that specified the location would be over there. So that's another issue that might come up. Lots of other issues, but I'm not going to go into all the possibilities. Here's our timeline. So here we are now. In a couple of weeks, we will send out that notice and start that 90-day time to file claims. The claims filing period would end January 24th, would be the last day to file claims. The state engineer will investigate all filed claims for validity and for their basis and for their definitions, whether the claim is being used as the claim, whether the water is being used as the claim states. And in May, we would get around to publishing the list of unclaimed rights. It's a lengthy process, first of all, because of the statutory required time frames, and second of all, because of the quantity of information we have to digest and do the work to produce. In May, the list of unclaimed rights is published, and there's an objection period, which would end in August. And then we'd continue investigating all the claims, and we anticipate publishing the proposed determination for the court and sending out notice of it in February of 2020. The objection period would begin, and we would hold a public meeting, and it would end in May. And I've kind of outlined the process from there. We would resolve objections and publish a final notice in the local newspapers and seek a decree from the court. It's a big question here. Let's hear yours.
What is the purpose of the May 19 public meeting? Is that to disclose the proposed determination or just provide additional information going forward?
Okay, so what is the purpose of the meeting in May of 2019? The purpose is informational to help you understand what is the lure, what it means, the list of unclaimed rights and of record. Let me slow down. What the list of unclaimed rights of record is, what it contains, how to digest its information, to help the public get some questions answered and, informational so that they can determine whether or not they should participate by filing an objection at the court. Objections to the list of unclaimed rights, as well as objections to the proposed determination. So in each case, objections need to be filed at the court with a copy filed with the state engineer. But it is a court process, a court procedure, so such objections must be filed with the court. So those meetings, both the list of unclaimed rights meeting as well as the proposed determination meeting, both would be informational. So again, not required attendance. Moving on. Will I lose my water right? Water users using your water right in conformance with the records on file must file a claim and then have nothing to worry about. But again, they must file a claim. Individuals using water without a water right of record are required to submit a claim now. Like that Dos Equis man, it's his last opportunity to get this on record. For the last 100 years, it's going to be foreclosed on him after this process. So they risk being barred from future claims and use. If the water use authorized under the water right has fallen out of use for 7 years or more, that water right or a portion of it not being used would be recommended to be disallowed in the proposed determination, with a recommendation that the court declare such a right forfeited. And that is per Utah statute. After 7 years of non-use without a non-use protection, the water right is subject to forfeiture. And that brings us to the end of the meeting. You can contact my supervisor, Blake Bingham. He is the Assistant State Engineer over Adjudication. I'm Gary Brimley, and the team leader I mentioned is John Bream. Here's our contact information, and it's time for me to also check the online just in case anybody submitted a question by email, which is possible. And it tells me there isn't. Yes, sir.
Okay, I have the same question that I asked earlier, the difference between shares and rights. So we're all going to get this paperwork in the mail in the next couple of weeks. If we have shares on a ditch company, do we or should we still fill that paperwork out saying, hey, I have a claim on my shares on such and such ditch company?
I appreciate that question. We get it all the time. So let me reiterate it for the recording. He asks, do we or should we, or would it be a good idea, all sorts of ways to phrase it, should we file a claim if we are a shareholder in a ditch company? And the best answer I can give to you is definitely be proactive about it. Participate, and if you want to, file a claim. If we identify that your claim must be associated with a share company, we would put your claim form on that company's water right, as well as submitting that claim to the courts. And there is no reason at all for me to ever discourage someone from filing a claim. So definitely file your claim if you feel like that. Now, again, it is the responsibility of the water right owner to file a claim, but sometimes the water right owner might not be aware or might not be professionally savvy enough to know how to do it, and you're welcome to involve yourself in their process or help them or file it yourself or do what you need. The best we can do is give notice and watch the returns. Yes, sir.
Well, okay, let's say on a spring, on my property, I have a building onto it. Salt Lake City claims they own all the water in all the canyons. And would that fall under a permit if I use that permit through Salt Lake City?
So let me see if I have understood the question very well. You have a parcel of land in the canyons maybe, and there's a spring on your land probably, and you use that water, or potentially. And he's asking if he might have a claim to it, or if Salt Lake City is claiming it.
Well, Salt Lake City says that they claim they own all of it.
So what I would caution you against is such generalities. I would say that Salt Lake City does have major interest and does claim a lot of the waters of the Canyon Creeks, but I cannot affirm what you allege, that Salt Lake City owns all the waters. They actually don't. They own a lot of it. So if you have a spring and you think you have a claim to the waters from that spring, I would suggest you file your claim and substantiate why it's a valid claim by providing whatever records you can to substantiate that. Yes?
Go back to the last slide.
The information is right here. Yes?
And this is a personal question. I heard you correctly, 1935, if a home was built and using water prior to that period, are they eligible to file for a claim?
So the underground water statute was adopted in 1935, and if a home has a well that was drilled and placed to use prior to 1935.
No, not personal well for the home, but a personal well, personal water source for the community.
Okay, a water source for the community water source.
And
So,
the house was built in '25.
so let me maybe rephrase that question and see if I've understood the question. You're wondering if there would be a water right attributable to a home that was built in the 1920s on an underground water source?
Yes.
And the answer is, if the water from the underground source was in use prior to 1935, there would probably be rights attributable to that, and it would be the claimant's prerogative to show the evidence for why that is. So provide that the home was, provide us your deeds, show us that the water was in use.
Yeah, okay.
Show us that the water was in use pre-statutorily. So the underground waters statute was 1935, and the surface waters statute predates that in 1903.
Thank you.
You're welcome. Any more questions? Yes, sir.
Read a sentence from your letter that you mailed out. Typically, less than 2% of the individuals who receive this notice will have a valid claim that requires participation. Of those receiving this notice, how is a valid claim determined that would require participation?
Good question. So the question is, of those people who have received this notice, how will you or how will I know whether I have a valid claim? That's the essence of the question. So you can know if you have a claim that you might want to file if you're using waters from those natural sources, such as a well or a spring, a stream, a river. If you're using that water, that's a starting grounds. If you're not using that water, the likelihood diminishes exponentially. So if you're not using that water, it's not likely. So who's using the water? Well, if the water is being provided to you, not by yourself, not by your own operation and maintenance, you're not taking care of the well, but the water is being piped to your house, you have a culinary connection for which you pay a monthly bill, then you're not likely a claimant. Unless you have your own source, private or shared, amongst a group of users. If that's the case, then you are more likely to have a claim. I went back to this slide because he asked about 2%, and the numbers here might work out to somewhere around 2%. There are 150 rights of record. Obviously, there might be rights not of record, so that might push us over the 154 here. And 7,000 plus people got the notice, so that's why the summons letter says 2%. Yes, sir.
Will you automatically, will we be on the list, or
You'll be, so all 7,312 people that got the summons letter will also get the notice to file claims, and they will also get the notice that the list of unclaimed rights has been published and filed at the court, and where to access that list. So if you don't get a letter, then you certainly are welcome to contact our office following these time frames. So if you don't get a letter, I can only imagine it might be because somehow it got lost in the mail, but the same mail lists will be used as were originally used. So if you got our original letter, hopefully you should be getting the second and third letters.
The reason I asked that is that I got the notice on Big Cottonwood Creek area, but I haven't got the other notice.
Okay, the notice to file claims, and he's mentioning another subdivision that we started last month. So we held a public meeting last month. It was the Big Cottonwood Creek. And the notice to file claims on that went out about a week and a half or 2 weeks after that meeting. So we have sent out the notice to file claims on that subdivision. And if you didn't get the mail on that one, then I don't know what happened, but you're welcome to approach our office and find what resources you need, whether it's a claim form or what you need for that subdivision. And same with this subdivision in time. You come to our offices and we'll help you get your claims, help you figure out what your claims need to be. I'll go over here and then I'll go over to this one.
I'm just curious, is there a possibility if you don't happen to be on the list, you might have a claim? Is there a mistake that could have happened or no?
So back to that list of unclaimed rights and the top issue on this slide, the list of unclaimed rights will be published with water rights in the record owner's names. So the owner of record is whatever record the state engineer has, and that record could be very old. So that owner of record might be somebody else's name, yet it might be a water right that you claim. And so in order to digest that and find out if your water right or your potential claim shouldn't have been on that list, you might need to use our map interface, because the geographical information is the best way to obtain water rights information. Over here.
How can you tell if you're on the 154?
How can you tell if you are one of the 154? Okay, so rights of record are of record, and their geographical information has been entered into our database. And we can show that by map, and maybe now's a good time for me to open up our water rights website. So this is waterrights.utah.gov. And on our homepage here, we have a map search feature. And I think after this question and after this demonstration, we will probably aim to close the formal part of the public meeting. So using the map interface, actually, let me go back to our homepage. Using adjudication, so I'm clicking on adjudication, active adjudications. And we can, so our staff can certainly help you navigate this if you need some help. What I suggest is you go to the active adjudications and click the little map button. So this is publicly accessible, and it will bring up a map of the 154 rights of record in the Little Cottonwood Creek Subdivision. And if your property is tagged with a little water icon, then that's all the more likely that there's a water right in your vicinity. Whether it's your water right is always another matter. So somebody could be diverting water from, the stream in your vicinity, and it could be their water right. A question over here.
Your server's down.
That's unfortunate. Let's see if, did I have a question over on my right? Okay. Let's just see if we can maybe make sure we're connected to the internet. Let's see if this'll, 500 internal, I think 500 means we are connected to to the internet broadly, but that the water rights server couldn't serve it up. More questions? Let's conclude the public meeting. So thank you for attending. And if you have more in-depth questions, our staff will hang around out in the halls. We do have mapping showing where these 154 rights of record are. They're printed on some larger format maps out in the hallways. And so you're welcome to look at that with our staff. But thank you for coming tonight. This gentleman in the hat.
Thank you.
How
That was
was
it.
that?
Very informative.
Good. Glad to know.